Okay, so good morning. Today's daf is Kaf Tet 29. We are on Kaf Chet Amabet. We're a little bit behind. We are at the fourth to last line in the narrow lines of Kaf Bet Amud Kaf Chet Amud Bet. We are at Amar of Chista. One, two, three, four. Fourth word from the end of the line is Amar. And we're in the middle of a discussion of relatives who cannot testify against one another. And because we're behind a bit, we're going to jump right in. And again, picking up fourth to last line on fourth to last narrow line on Kaf Chet Amabet. So Rav Chisda and Rabba Barakana note two relatives who may testify against one another. Listen to this. Rav Chisda, avi chatan v'avi kala me'idin zeh, that if you have the father of the groom and the father of the bride, meaning the in-laws, they are allowed to testify against one another. V'lo damu lahadadi ela ki achla ladana, that they are compared to one another like and therefore their connection is like a bad cover, a plug, as Rashi says, a plug that doesn't really fit the jug. And so as a result, it's not such a great fit. And so therefore they're they're not actually considered relatives. So that's ruling number one. Ruling number two, Amar Rabba Barbarchana, made Adam leishto arusa. A person can testify against their arusa. That, again, arusa means that they performed kedushin, but not nisuin. They've done the first step of the marriage, but not the second. And so as a result, that's why they're allowed to testify against one another, according to Rabbi Baruchana. But Ravina lo amran ela apuke mina. But Ravina says that when Rabbi Baruchana said that, it was only referring to taking money away from her, because then it's not like they have any kind of animosity, and so as a result, he would be believed. But in order to get her money, we're not going to believe her, because why won't we believe her? Because she is because he's going to be married to her, and so as a result, that's why we're not going to allow him to sort of indirectly benefit from his case. Velohi, and this qualification is not accurate. Lo shnala puke, lo shnala yule, lo mehemen. That actually, in all cases, we're not going to believe her, and so or believe him about her. So as a result, in the end, although Rabba Barbarchana originally seemed to be saying that one may testify about one's arusa, in the end we say that you're not. And my daitech. Now, what was the reasoning to potentially allow the arusa to testify? Kida Amar Rabbi Chia bar Ami Mishmei Deula. Well, it's based on the following teaching of a bright. This is elsewhere taught as a brisa, but in any event, here it's being taught in the name of Ula. Ishto arusa, if a man is wife is only an arusa, meaning that they've only done kedushin, lo onain, he does not actually become an onain for her. He does not go into mourning for her. V'lo mitamela, and if he's a kohen, he's not going to become tame for her. V'chein he, and similarly when it comes to her, she's not going to. Lo onenes, v'lo mitama lo, and she's not going to, doesn't have to become tame for him. Mesa Ena Yorsha. If she dies, then he does not inherit her. Mesu Gova Ksubasa. And if he dies, she gets her ksuba, but she doesn't get anything else. So the bottom line is that we see that this is not a full-fledged connection. Indeed, in our Mishnah, we saw one opinion that said that the only time people can't testify against one another is if there's an inheritance possibility. So this would be seeming to be consistent with that. So Hassam, but the Gemara says that this is the problem with that thinking. Hassam b'she'iro tala rachmana. There, it's based on the concept of she'iro, a really close relationship. Akati lav she'irohi. And as long as she's an arusa, she's still not that close relationship. But here, it's not about the physicality of it. It's not about the sort of the true relationship. That isn't what matters. What matters is the sense of closeness. And vaha Once you're engaged in that way, that you're already performed the first step of marriage, well, then you better believe that there's a sense of close feelings of, and therefore you would not be able to testify.
There's a
Okay.
nafkamina regarding a coin, though. She cannot, if she's divorced, even as an arusa, she cannot marry another coin, right?
Yes, correct. But that has nothing to do with whether or not the person to whom she was an arusa inherits her or not.
No, but that
it
demonstrates some measure of closeness that she can.
Yes, I hear that, but the bottom line is that there's actually a discussion whether or not whether or not the person would be allowed to marry in that situation. It's not completely clear, but you're absolutely right that that's, I think, where we end up. Okay, so the Mishnah noted a stepson is disqualified from testifying against his stepfather and vice versa, but not the stepson's son or son-in-law. So as additional background, so that's point number one. That's what we're going to be talking about, the stepson. But we're also going to be talking about the a brother-in-law. And here, when we refer to a brother-in-law, we're going to be talking about your wife's sister's husband, who's also, I mean, it's your brother-in-law who's married to your sister-in-law. It's where both of the couple are in-laws. Okay, right?
No, there's a brother-in-law married to your sister.
No, that's true, but your brother-in-law is also married to your sister-in-law.
Oh.
Right? If your wife's sister marries somebody, in addition to, right, your wife's sister marries somebody,
right.
In addition to her being your sister-in-law,
her sister,
her sister being your sister-in-law, but so is her husband, your brother-in-law.
Well, second removed.
Yes, second removed, but that's
the
case that we're talking about because of the second level of removal. You're exactly right to point that out. Okay, so the point is that
that's strange, isn't it?
Yeah, it is strange. So, yesterday we saw a brisa that taught by Rabbi Chia that noted that there were 8 relationships where the person's son, and the person's son-in-law would be prohibited to testify. And let's go through those relationships. That's a brother, an uncle, whether it's an uncle of your mother or your uncle of your father, meaning your father's brother or your mother's brother. That's 2 and 3. 4 is your sister's husband.
Right.
5 is your uncle-in-law, meaning your father's sister's husband or your mother's sister's husband, who's really your uncle, but you know that they're not the blood relative. Those are 5 and 6. 7 is your mother's husband, who may not be your father. And 8 is your father-in-law, which is your wife's father. So those are the 8 relatives where we say that not only can they not testify, but their sons can't testify against you, and their sons-in-law can't testify against you. Okay, so those all 8 cases. In our Mishnah, there was a 9th case, namely the wife's sister's husband. That was the brother-in-law case. And so we said that also in that case, the son and the son-in-law would not be able to testify. So we have, as a result, a brisa that references 8 cases. Our Mishnah references 9 cases. With that background, we're now going to look at 2 brisas that are very unclear as to what they mean. And we're going to offer 3 interpretations. The first 2 interpretations are going to be rejected because it leaves us with nobody saying what either one the brisa says or what the Mishnah says. But let's take a look, and now we'll see this inside. Tana Rabbanan, Chorgo levado. The brisa says, the Tanakama of the brisa says, only the stepson. Rabbi Yossi Omer, Giso. Rabbi Yossi says, the brother-in-law. The Tanya Idach, we've got another brisa, Giso levodo. Just the brother-in-law, only the brother-in-law. Rabbi Yehuda Omer, Chorgo. And Rabbi Yehuda says, the stepson. Now, we are assuming that the Tanakama, that we've only mentioned 2 names here in these 2 brises, Rabbi Yehuda and Rabbi Yossi. And so as a result, because we've only mentioned two names, we're assuming that the Tanakama, and in fact, we're going to not change this assumption, the Tanakama in each of these two brises is the other one. So the brisa, the first brisa, the Tanakama is Rabbi Yehuda, and the second brisa, the Tanakama is Rabbi Yossi. So now that we've got these statements, right, in both cases, Rabbi Yehuda mentions the stepson, and in both cases, Rabbi Yossi mentions the brother-in-law. But it isn't clear what these two opinions are saying about the other item. So my kamar, what are they saying? Try number one. Ilema hachi kamar, if we want to say that this is what they're saying, Chorgo levado v'hu adin legiso, that the stepson is alone, meaning that his son and son-in-law would not also be disqualified to testifying. And the same thing is true for the brother-in-law, that the brother-in-law alone, but not the brother-in-law's son or son-in-law, excuse me. Again, the stepson's son or son-in-law would not be disqualified. And similarly, the brother-in-law, son, and son-in-law would not be disqualified. And Rabbi Yossi is effectively saying the same thing, but in the other direction, that the brother-in-law is only one is a lone person, meaning that only he is invalid to testify, but the brother-in-law's son and son-in-law would not be invalid to testify. And the same thing is true with respect to the stepson. But but when in our Mishnah, we said that the brother-in-law also covers the brother-in-law himself, his son, and his son-in-law. So that now Mani, who is it? Lo Rabbi Yehuda, the Lo Rabbi Yossi. It ends up not being like Rabbi Yehuda or Rabbi Yossi, because both of them say that the brother-in-law would also be the only one disqualified without the son and son-in-law.
Wow.
Ve'ela hakikamar. So, all right, so you want to try something else? Let's try the following. Chorgo levado, avalgo gizahu uveno v'chasano. That when it comes to the stepson, Rabbi Yehuda would say that only he is disqualified, but when it comes to the brother-in-law, it would be the brother-in-law's son, and the son-in-law would all be disqualified. But also Rabbi Yossi Lamemar Giso Levado, and Rabbi Yossi says the flip side. He says only the brother-in-law, Aval Chorgo v'hu uvno v'chasano. But when it comes to the stepson would include the stepson's son and son-in-law. But then Tani Rabbi Chia. But then we have this brisa of Rabbi Chia. Shmona avos shehein esrim va'arba. He's the one who says that there are 8 in main categories, and from them we end up with 24 because they include the person's son, and the person's son-in-law. That 8 times 3 is 24. So come on. That it doesn't follow anybody. Lo Rabbi Yossi, lo Rabbi Yehuda, because both of them end up holding that there are 9 such relationships. Ella hachikamar. So here's what it's got to be.
Didn't we have there was another man that almost had 32 instead of 24, right?
Well, that was 32 was when we said that not only was it Beno, but Ben Beno as well. Right. There was an opinion that sort of threw in an additional relationship. We did not end up, that was a comment on this brisa, but the brisa itself doesn't refer to 32. That was, we asked the question from this brisa on that opinion, and we ended up saying, well, maybe there's another opinion. But in the end, I believe the Gemara rejected that opinion and did not end up saying that approach, and limits it to the son and son-in-law and the original person. So as a result, there is no, in fact, opinion that in the end says that there are 4 for each, and so therefore 32. So Ela hachikamar. So now, how do we get Rabbi Yossi and Rabbi Yehuda to be consistent with both our Mishnah and that brisa? Chorgo levado. So Rabbi Yehuda would say that's just the stepson, aval giso hu v'no v'chasano. But when it comes to the brother-in-law, it would include the brother-in-law himself and his son and his son-in-law. V'as Rabbi Yossi lememar giso levado v'chol shekain chorgo. That, and Rabbi Yossi says no, the brother-in-law is all by himself, is the only one disqualified without without his son and son-in-law, but not only the brother-in-law, certainly the stepson. So because the stepson is in some ways less related to you than a brother-in-law. And so as a result, both of those, according to Rabbi Yossi, neither of those cases, neither the brother-in-law nor the stepson would include that person's son and son-in-law. And therefore, Umas Nisan Rabbi Yehuda, our Mishnah would be Rabbi Yehuda, and Brisa Rabbi Yossi. And the Brisa, which, and because our Mishnah references 9 cases, and the 9th case being the brother-in-law case, and so that matches perfectly with now our understanding of Rabbi Yehuda, and the Brisa is Rabbi Yossi. The Brisa that says that there are 8 cases, that's Rabbi Yossi, so everything aligns perfectly. So Amar Rabbi Yehuda, Amar Shmuel, halakha Rabbi Yossi. The halakha is like Rabbi Yossi. Now, at the moment, we're thinking that the halakha is like Rabbi Yossi, not about what we just said, but rather, if we take a look in Rashi, 1, 2, 3, 6 lines up near the end of the line from the bottom of Rashi, halakha Rabbi Yossi, kasal kadaita Rabbi Yossi demas nisin. It's like our Rabbi Yossi in our Mishnah. Delo pasol elakarav haroy liyeresh. That the only relative who's unable to testify against you is one who is capable of inheriting. Begiso, but when it comes to your wife's sister's husband, Eino roy liyareshu, he's not able to testify, and so that shows that Rabbi Yossi would say that a brother-in-law can testify against somebody. Are we saying that? That's what the Gemara thinks at the moment. The Gemara thinks that as a result, we would allow 2 brother-in-laws to testify. So, hahi matanta dehave chasime ala tre gise. And there was a gift document that said that somebody gave a gift to someone that had 2 brothers-in-law that were signed on it, where the brothers-in-law were brothers-in-law because they were each married to 2 sisters. But they were not the first connection, they were essentially a second connection. So Saba Rav Yosef La'achshura, Rav Yosef thought that he was going to make it kosher because the Amar Rav Yehuda Amar Shmuel halakha Rav Yosef, because he thought the halakha is like Rav Yosef in our Mishnah, where it says that if you can't inherit, then you can testify. Meaning you can even testify together. So Amar Le Abaye said, 1 second, Rabbi Yossi demasnizin demachasher begiso. How do you know that you're referring to Rabbi Yossi in our Mishnah, who says that a brother-in-law can testify? Dilma Rabbi Yossi de Baraisa de Pasel begiso. Maybe it's Rabbi Yossi of the Brisa who says that a brother-in-law cannot testify. He allows the brother-in-law's son and the brother-in-law's son-in-law to testify but he won't allow the brother-in-law himself to testify. So Rabbi Yosef replies, Lo salkadai, don't think that. D'amar Shmuel, because Shmuel says, and the halacha is generally like Shmuel when it comes to monetary matters, Kagon ana upinchas dahavinan ache v'gisei, that when it comes to me and Pinchas, we are brothers and brothers-in-law, because they, of course, were brothers, and they married 2 sisters. Aval Gisei, and he was identifying who cannot testify. And so he was giving himself and Pinchas as an example. And what's the implication of that? Aval Gisei de Alma Shapir Damid, but maybe brothers-in-law are able to testify. And Abaye responds back, no, that proof from Shmuel's statement is not a definitive proof, because maybe Vidilma could go ano Pinchas mishum degisu kamer. Maybe even though he and Pinchas were actually also brothers, the fact is that what he was trying to say is the relationship that I have to Pinchas through my wife is sufficient to prevent me from testifying. So Amar Le, Rav Yosef says now, and Rashi tells us that he's now speaking not to Abaye to respond to Abaye's point, but rather speaking to the recipient of the gift and saying, hey, you recipient of the gift, I've got an idea for you. Listen to what I should suggest. Zil Kanya Ba'adi Masira. Go find the witnesses who saw the handing over of the document, Rabbi Elazar, and we'll hold like Rabbi Elazar, because Rabbi Elazar, of course, is the one that we saw in many times before during our travels through Shas, and we saw relatively recently in the at the end of Baba Basra that he holds a de Mesiru Karti, that who matters is the witnesses that watch the handing over of the document, and the people that are actually written on the document are less important. But that's a problem. Abaye responds, V'ha'amar Rabbi Abba says, Moda Rabbi Elazar b'mizuyav mitocho shehu pasul. But when there's a problem in the document itself, and here, because there are two brothers-in-law who signed on the document, there's a problem in the document itself. And in that situation, Rabbi Elazar does not simply allow the witnesses to the handing over to be sufficient. In that situation, he's going to find it problematic. So Amar Lei, so again, Rabbi Yosef now speaking again to the recipient of the gift, Zil lo shavke li de ozvine lach. Look, go away because they're not going to allow me to give this gift to you. Meaning I've tried every which way to give this gift to you, but Abaye has sufficiently, questioned my reasoning, and as a result, I'm not able to actually, he's made good points, and therefore I can't actually give you this gift.
But in this case, weren't they the two of them actual brothers?
Well,
Okay,
in
the small
Shmuel's
one.
statement, statement,
Right.
they were actual brothers.
Right.
But Abaye points out that it's not clear from Shmuel's statement whether he was pointing out the fact that just having been brothers-in-law would have been sufficient, or whether he was pointing out it was only because they were actual brothers. And so as a result, the proof that Rav Yosef tried to bring was not a valid proof.
Right, because if they're actual brothers, the whole thing is a moot point because they can't.
Of course, exactly. Then they certainly can't testify. All right. So now we had in our Mishnah, Rabbi Yehuda said that if one's daughter has children, then her surviving husband, when she dies, remains a relative who cannot testify. Okay, so that's what Rabbi Yehuda said. Rabbi Yehuda Omer, so that was what he said. Amar Rabbi Tanchum, Amar Rabbi Tavla, Amar Rabbi Baruna, Amar Rav. So it's said in the name of Rav, halacha Rabbi Yehuda. The halacha is like Rabbi Yehuda. However, Rabbi Amar Rav Nachman, it said in the name of Rav Nachman, ain't halacha Rabbi Yehuda. The halacha is not like him. V'chein Amar Rav Bar Chana, Amar Rabbi Yochanan. Similarly, was said in the name of Rabbi Yochanan, ain't halacha Rabbi Yehuda. So how do we end up? So let's get a story. Oh, no, I'm sorry. The Ika Damasni law, Laha de Rabba Bar Barchana, aha. Now, although we just heard that Rabbi Bar Barchana had said this in the name of Rabbi Yochanan, that the halacha is not like Rabbi Yehuda, we have another statement in the name, another possible tradition with respect to what Rabbi Bar Barchana was talking about. And it refers to the following. At Zu Darash Rabbi Yossi Aglili. Rabbi Yossi Aglili learned about the following verse. Uvasa el ha-kohanim. You have to go to the Kohanim, Halaviim, who are Levites, the el ha-shofet, and to the judge, Asher yeh b'yamim haim, that are in your day. Now, of course, you have to go to the people that are around in your day. Would it even be considered to you that you would go to somebody who's not around? No, the point is that this is highlighting that if the moment that they are testifying, if the moment that you're testifying, the judge is not a relative, then it's okay for you to go to them at this time. But even though you were a relative to him beforehand. So this refers to a situation where the person was a relative and then became distant, and we're going to say that he's allowed to judge. So Amar Rabba Bar Barchana, Amar Rabbi Yochanan, Halacha Rabbi Yossi Aglili. And it was a statement of Rabba Bar Barchana, again in the name of Rabbi Yochanan, but it was here that he said that the halacha is like Rabbi Yossi Aglili. So it wasn't a statement about Rabbi Yehuda. But now we're going to go to a story that shows that, in fact, we do not paskin like Rabbi Yehuda in our Mishnah. And
So
that
what would
once...
be the case?
What?
The case would be what, a divorce or a widow?
A divorce or widow. Both of those are possibilities. So again, your we won't do any names of people in this situation. So Reuven's son marries Reuven's daughter marries Yonatan, and then Reuven's daughter dies. And even though she has children, Reuven has descendants, and those descendants wouldn't be able to testify against Reuven. Yonatan, who married his daughter, would be able to testify against him, and similarly, and would be able to serve as a judge. So we have an example. Ben Chamud Mar Ukva, the sons of Mar Ukva's father-in-law. So these are his brothers-in-law, meaning from his wife's brothers. So Kurovim v'nisrachaku havu. They were relatives. They were, and then they became distant because Mar Ukva's wife died, according to Rashi. Asu l'kamei ladina, and they came in front of him for a case. As we turn to Kaftet Amud Aleph, Amr lahu pasilna l'chuladina. I can't testify from you. I'm disqualified. Amrulay, they said, my daitech. 1 second. Who are you holding like? Rabbi Yehuda? You're holding like Rabbi Yehuda? Anan maisinan igarta ma'arava. We'll bring you a letter from Israel. De'ein halacha Rabbi Yehuda. The halacha is not like Rabbi Yehuda. So Amr lahu, Mar Ukva said, no, atu bekaba dekira idabaknad b'chu. You think I'm so tied to you with wax that that I can't, that's the reason? No. The lo kamina pisilna lechuladina. Elo mishum delot saisisu dina. The reason that I told you that I'm disqualified is only because we have such a close relationship that you won't listen to me. And so as a result, that's the problem. Okay, so as a result, again, we see that the halacha is not like Rabbi Yehuda. Ohev zeh a person who is a beloved person is somebody, is a groomsman. So a groomsman would not be allowed to testify, according to our Mishnah. V'kama, so how long is, I'm sorry for not scrolling. So how long is it that this prohibition would apply? So 2 opinions. Amar Rabbi Abba, Amar Rabbi Yirmiyah, Amar Rav, Kol Shivas Yimei Mishnah. It would apply for all 7 days of the Sheva Brachos. The Rabbanan Mishmei de Rabba Amri, no, Afilu Miyom Rishon Ve'elach. Even as soon as the wedding is done, meaning as soon as the day of the wedding is done, that's it. That kind of closeness relationship does not continue on, and you would be able to testify. Okay. Hasone kol shalo diber. We said that an enemy is some who also can't testify, is also somebody who with whom you don't speak for 3 days because of your how bad you feel about the person. So Tana Rabbanan, v'hu lo oyev lo. And we're going to learn this from the fact that in connection with the pasuk that relates to sending somebody out to exile for having killed someone accidentally. So there we're going to say that the person can't have been their enemy. Now, Ye'idenu, and so we're going to say that even though that pasuk is actually about exile for an inadvertent killer, but because this law is taught elsewhere, for example, it's taught in Dvarim, this pasuk is Bamidbar Lamed Hey, pasuk Kaf Gimel, because it's also taught in Sefer Dvarim, we're going to say, don't apply it to the case where it's talking about, namely the case of an accidental murder. Instead, say that it's telling us that a person who's your enemy can't testify. V'lo mavaksho mvakesh raso, and similarly, somebody who seeks your ill, again, another concept of enemy, yedinenu. And that repetition tells us not only can he not serve as a witness, but he also can't serve as a judge. Ashkechan sonei ohev minalan. Okay, you've shown from this pasuk that somebody who's your enemy can't testify or judge your case, but how do you know that somebody who's your friend can't? So kari b'hei hachi, read it as follows. V'hu lo oyev lo, and he's not his enemy. V'lo ohev lo, and similarly not his friend, ye'idenu. And that tells you about testifying. V'lo mevakesh ra'aso, and he's not going to seek his misfortune. V'lo tovaso, and he's not going to seek his benefit. Yedinenu, and then he can judge him. So the point is only a person who doesn't want either benefit or misfortune can judge, and only a person who's not an enemy or a friend can serve as a witness. So midei ohev ksiv. 1 second, but you're reading in words that aren't actually written. Elasvarahu. Rather, it's just logic. Oyev my time. Why don't we allow somebody who's an enemy to testify? Mishum de mirachka daite, because his attitude is distant. He's not in favor of the person. Ohev nami makarva daite. So similarly too, when a person's attitude is favorable, we're going to have a problem as well. All right, V'Rabbanan. Well, 1 second. What do the rabbis do? Because the rabbis in our Mishnah don't agree with this and say that actually, while we will not allow a friend or enemy to serve as a judge, we will allow them to serve as a witness. So v'Rabbanan high lo oyev lo below mivakesh ra'aso my darshebe. So what do they do with the two halves of that verse? Because we use the two halves, one to tell us about not judging friends and enemies, and one about not witnessing for friends and enemies. But the rabbis say that you can serve as a witness. So chad l'dayan. So you use one half of the verse to tell you that you cannot serve as a judge. Ida kedetanya, and you use the other half like the following brisa. Rabbi Yossi Rabbi Yehuda, Rabbi Yossi, the son of Rabbi Yehuda, said, "V'hu lo oyev lo v'lo mavakish raso." That why do we have this pasuk that says you can't be the enemy and you can't be the one who seeks his misfortune? Mikan lishne talmidei chachamim shesonin zed zeh she'ein yoshvin bedin ke'echad. That this is telling us that when you have two Talmidei Chachamim, two wise people who are going to potentially serve as a judge, they cannot serve as judges together if they don't get along. Okay, so that brings us to the next Mishnah, and the next Mishnah reviews courtroom procedures. So
wouldn't it be common for people to bring their friends as witnesses on their behalf?
Yes, and that's why we in the end, I believe we paskin like the Rabbanan who allow friends to be witnesses 100%. So how do we examine these witnesses? We bring them into the room and we try to cause them to be afraid, namely of lying. And we then send everybody else out of the room. And we ask only and leaving just the most prominent of the witnesses, and we ask that person, how do you know that this guy owes money to that guy? If he says, "Who amar li shani chayav lo," the guy admitted that he owed him money. Ish ploni amar li shehu chayav lo, or somebody told me that he owed me money. Lo amar klum. That is meaningless. That testimony does not result in any kind of recovery. Ad sheyomer, until the person says, "V'fanenu hodu lo," in front of us. The defendant admitted shehu chayav lo ma'asayim zuz. He admitted to the plaintiff in front of us that he owes him 200 zuz. And then afterwards we send out the first guy and we bring in the second guy and we ask him the same questions. If we find that they're both testimonies are equal to one another, that they correspond. So nosin v'nosin b'davar, then we're able to deliberate and decide the case. If they don't, then they're thrown out as witnesses because we don't have two common witnesses. Shnaim she'omrim zakai. Now, two of the judges say that the person is not liable, but echad omer chayav, and the one says that he is liable. So then zakai. Well, then two beats one, and we end up saying that he's not liable. Shnaim omer chayav, zechad omer zakai chayav, and vice versa. If two say you're liable and one says you're not, so then you're liable. Now, what about the following? Echad omer chayav, echad omer zakai. One says liable, one says not liable. Afilu shnayim mezakin, o shnayim mechayvin. And then, or even if two say you're not liable or two say you are liable, the echad omer eini yodeya, and the third judge says I don't know. Well, then that is not enough to decide the case. Even if it's two say liable, and one says I don't know. If two says liable and one says not liable, so then you're liable. But if two says liable and one says I don't know, we don't say, well, it doesn't make a difference what he decided, but rather we say that there wasn't a third judge because the third judge didn't reach a decision. And so as a result, Yosef and Hadayanin, you have to, in all of those cases, if the person says I don't know, even if the other two judges are in agreement, we have to add judges to the court. And as we saw before, we add two judges and we see what they say. And if they end up with the same, well, then of course then we're done. But if we end up with a majority, so then at least three judges, so then we are going to be okay, and we will reach a conclusion.
We had a discussion in the Gemara, didn't we, a long time ago? I've seen a long time, where we talked about adding a judge who was. Do you really consider if there are three of them there, then there are three of them mechatchila, so then we consider them as three judges versus, well, we're adding one later on, so that person wasn't there.
Two things. One is we're not adding one; we add two. And
No, no, no.
second,
Forget before we get to that. If we say there are three judges, I
mhm,
understand what you're saying. But if we have three, and one says I don't know, but in the beginning we had three. So how do we now say we didn't have three by
because
the
the
one
one
says
of the
I don't
judges
know?
refused to reach a verdict. Because the judge refused to reach a verdict, didn't say either liable or not liable, it's as if he was never there in the first place. That's exactly the teaching of our Mishnah right now. That's precisely the teaching. We have a lot to go through, so I'm sorry that I have to
No, I
cut
know.
things off, but Gamru as a davar, so now they reach a conclusion, they reach a verdict. Hayom machnisin osan, so they bring back the litigants in. Hagadol shebedayanin omer ish ploni ata zakai, ish ploni ata chayev. So he'll say, you are liable, you're not liable, whatever it is that he's, whatever the verdict is that they reached, that's what he's going to tell the people. How do I know that when the judges leave, that no judge should say the following? Ani mizaka and I was the one who was saying that you were not liable, and it was because the other two judges said you were liable that you became liable. But what can I do because they outnumbered me? Al zenemar Holech Rachel Megala Sod, that if he's a gossip monger who reveals secrets, meaning you shouldn't, this is from Mishlei, Parak Yud Aleph, Pasuk Yud Gimel, and we say that you shouldn't, be a revealer of secrets. And so as a result, the deliberations of the judges is intended to be private. Okay, so what do we tell these witnesses? So three different viewpoints on what we tell the witnesses. Amar of Yehuda, Hachi Amrin lahu, in order to scare them so that they don't lie. Hachi Amrin lahu. This is what they say according to Rav Yehuda. Nesiim v'ruach v'geshem ayin ish mishalel b'matas shaker. That when a person takes pride in a dishonest action, when a lie, then clouds and wind, but no rain. Meaning that when we're going to end up, if you end up not telling the truth, we're going to have a famine. And so as a result, that's going to scare them. Amrle Rava said to Rav Yehuda, Yachli Lameimar, Shav Shanei, Hava Kafna, Va'abava Umana Lo Chalif. No, I can say that there could be 7 years of famine, but I'm not worried about it because people will still need my services. Yeah. And so even though there's a famine, I will be okay. So Ella Amarava, so Rava says, this is what they say. Amrin and Lahu, Mefitz v'cherev v'chetz v'shanun, ish oneh b'rei eight sheker. That we have a club, a sword, and a sharp arrow. That's what happens when a person bears false witness against his friend. So as a result, that shows that, again, you have to be worried about dying early. So Amrle Rav Ashi said, that's also not necessarily a good scare tactic. Yachli Lameimar, witnesses can say the following: Shav Shnei Hava Musana, Ve'inish below Shnei Lo Shachiv. You can have 7 years of plague, but a person who's is not supposed to die when they are except at the time that they're supposed to die. Meaning Hashem, in the first case, maybe a person could be not believing. In this case, in some ways, they are totally have total emunah in Hashem, and they say, whatever Hashem has decided for me, that's when I'm going to die. I'm not going to die a minute early. So Ella Amar Rav Ashi, so therefore Rav Ashi says, Amar Li Nasan Bar Marzutra, so Nasan Bar Marzutra so told me, Amrinan Luhu Sade Shakre Ograihu Zile, that a lying witness is negative, is disgusting in the eyes of the people who hire them. Why? Diksiv v'hoshivu shnayim anashim b'nei v'lial negdo v'yidu lemor b'rakta Elokim v'melech. And so what should you do? This is Izebel talking about how we're going to try and take away the fields of Nabos. And she says, listen, get 2 witnesses to say that he cursed the god. I mean, by Rachta there, even though bracha obviously means blessing, we're using a Lashon Saginar and saying it really refers to a curse, that they cursed God and they cursed the king, and therefore the person is liable to the death penalty, and you'll kill him, and then you'll be able to take his field. And so, but what does she say about the getting the false witnesses? She says, get them b'nei v'liyal. These are people who are corrupt. So even she refers to them as corrupt. So again, we see that the people who are hiring the corrupt people don't think that the people who are being hired are very good people at all. So as a result, you don't want to be that. As a result, you should make sure that you tell the truth. So those were the three possible statements in order to scare the witnesses. Now the Gemara is going to detail what the witnesses must say to be believed. Again, we saw that they need to actually have testified that the defendant admitted to the plaintiff in front of us that he was owed the money. But it turns out that hiding witnesses is not going to be sufficient. Amar hu Amar li. If you said, again, the Gemara quotes the beginning of the part of our Mishnah where it said that it doesn't make a difference if he just said that he owed me the money, that if he just admitted to me, the witness, that the defendant owed the plaintiff money, that's not enough. Aji Yomru Bifanenu Hodalo Shehu Chayav Lo Masayim Zuz. In fact, he has to admit into the plaintiff directly in our presence that that he owes 200 zuz.
What do you mean by hiding witnesses?
Sorry?
What do you mean by hiding witnesses?
Please give me a moment and you will see. Messiah Leila Rav Yehuda. This is a proof to Rav Yehuda. To Amar Rav Yehuda Amar Rav Sarach Sheyomer Atemedai. That somebody needs to say that you are my witnesses in order for this admission to be accepted. And we'll see exactly who makes that statement in a few moments. And now we're going to cite cases. Itmar Nami, and we had a similar statement. Amar Rabbi Chia, Amar Rabbi Bar Abba, Amar Rabbi Yochanan, Mana li biyadcha. You owe me 100. Amar lo hein, yeah, I do. Lamakar Amar lo teneuli. And the next day, the guy says, give it to me. Amar mishata ani bacha. What are you talking about? I was just joking. That wasn't a serious statement. Putter. The defendant in that case is not liable. Tanya Nami Hachi. And we have a brisa that says the same thing. Mana li biyadcha. Amar lo hein. Again, person says, you owe me $100. You say, yeah, I do. Lamakar Amar lo teneuli. And then he says to you the next day, give it to me. Amar lo mishadani b'cha. Well, I was just joking. Putter, he's not liable. V'lo owed. Ela afilu hichmin lo edim achori gadar. Even if the plaintiff put witnesses behind the wall. V'amrlo, and he says to him, Mana li biyadcha, you owe me 100. Amrlo hein, and the guy says, yeah, I do. Ritzoncha shetoda bifnei ploni uploni. Are you willing to admit it in front of X and Y, who happen to be behind the wall? Amrlo, misyari ani shema tchapini ladin. No, I'm not going to do that because I worry that you're going to, take me to trial. So Lamachar Amarlo Teneule. And then the next day, the plaintiff says, all right, give me the $100. And here are the witnesses that were behind the wall and heard you admit it. So Amarlo, Mashati Ani B'cha. No, I was just joking. Even so, Putter, the person is still not liable because the person himself didn't agree to have the witnesses hear his statement. Ve'ein Toan and Lamesis. Now, out of nowhere, and the Gemara is going to ask this, the Gemara Brisa concludes the court does not plead on behalf of one who encourages others to engage in idolatry. That's a mesis. So mesis, man dachar shmei. Who's talking about a mesis? We were talking about testifying in court about $100 debt. So chasori machzarava hachiktani. There's words missing in our Mishnah, in this Brisa, excuse me, and we need to read it as follows. Im lo ton, ein toan and lo. When it comes to a monetary case, if the defendant doesn't make a plea, we're not going to plea on his behalf. But uvadini nefashos, when it comes to capital cases, avagabdelo toan lo. Even if the defendant doesn't make a plea, we will make the arguments for him because we need to make sure that this person is actually deserving and isn't trying to, do the ancient version of death by cop. The ain toan lamesis. However, when it comes to somebody who's accused of causing other people to engage in avodah zarah, then we will say we don't necessarily engage in pleas on his behalf.
Death by what?
What?
What did you say?
Death by cop. Death by cop. That's where you go and assault a cop and try and commit suicide engaging in inappropriate behavior. But the whole reason you do it is because you don't want to commit suicide yourself. You want the cops to kill you for you. So Maishna, but the point is we worried about that. We don't want people to engage in that behavior. We want to try and protect people from that kind of situation, and therefore we will make pleas on their behalf, if even in a death penalty case. So Maishna Maces, why is a Maces different that we won't speak up for them? So Rabbi Chama bar Chanina, the Pirkei de Rabbi Chia bar Abba Shmieli. From the lectures of Rabbi Chia bar Abba, I learned the following: shiny maces. A maces is different. The Rachmana Amar lo sachmo v'lo sachas alav. You shouldn't have any mercy, and you shouldn't protect such a person. And so as a result, that's our way of not protecting. Okay. So Amar Rabbi Shmuel bar Nachman, Amar Rabbi Yochanan, Minayan she'ein toan lamesis. How do I know that we don't plead on behalf of a masis? Minachash kakadmoni. We can see it from the original snake in the story of Adam and Eve. The Amar Rabbi Simlai Harbe Ta'anos Hayalol Nachash Luton Lutidotan. He had a bunch of arguments that he could have made. Ma Lotan Lo Hakadosh Baruch Hu. And why didn't Hashem make these arguments on behalf of the snake? Lefisha Lotan Lahu, because he didn't make the pleas himself. So my Havalei, what could the snake have said in order to show that he was, really didn't deserve any kind of punishment? Divrei Arav, Divrei Talmud, Divrei Mishomin. When it comes to me, I'm just God's student. I don't hear anything. I'm not God. But and you, Adam and Chava, you heard the commandment not to eat from the Eitz Hadas from God, and so as a result, who should you be listening to? Divrei Rav Shomin. You should be listening to your teacher, namely to Hashem. And as a result, I shouldn't be to blame at all for any of this, because who do you listen to? You listen to the teacher. Amar Chizkiya Minayin Shekol Amosif Goreya. How do I know from this story that anybody who adds something to what God says is actually taking away? Shenemar Amar Elokim Lo Sochlu Mimenu V'Lo Sigubo. Because Chava tells the snake that Hashem has told her not to eat from it and not to touch it. But of course, God didn't say not to touch it. That was an thing that they came up on their own. But by attributing it to God, now they've actually made things worse, because then, according to the Midrash, Chava touched it, nothing happened, and so as a result, she was then felt that she could eat it. Rav Masharshia Amar Mehachal. Rav Masharshia says you can see that adding actually subtracts when you see the following: Amasayim v'chatzi arko. When it comes to the length of the Aron, it says that it's 2.5 amos long. So so Rashi explains that if you take off the word Aleph, the letter Aleph from Amasayim, it becomes Matayim v'chatzi. That would be 200.5. So we see that when you add a letter, you actually subtract 198. So you go from Matayim, which is 200, to Amatayim, which is 2. So, and Rav Ashi Amar, no, don't look at that one, but rather look at the curtains. Ashtei Esrei Yiriot. There were 11 curtains. And if you take off the ayin from Ashtei Esrei, you end up with Shtei Esrei, which is 12. So again, by taking off a letter, by adding a letter, by adding the ayin, you have subtracted. So that's those are two. Exactly. Addition by subtraction. Exactly. Or subtraction by addition. Right. Exactly. So Amar Abaye lo shanu elo da Amar mishata ani b'cha. So again, now Abaye is saying that the only situation where the defendant can get out the next day is if he says, "Listen, I was joking with you." But Aval Amar, as we turn to Kaftet Amabet, Lo Hayudvar Ma'olam. If he says that there was nothing, nothing ever happened, meaning there was no admission, I never said anything. Huchsa kafran. Well, then we've now when of course the witnesses come and show that they heard his admission, and now he's been proven to be a liar. So as a result, we are going to be able to find the defendant liable because he's a liar, and so as a result, we will, in that situation, not say that he's not liable. So
Is that the
Amalei.
case where the witnesses were hiding behind the wall?
It could be yes, it could be where the cases where the witnesses were hiding behind the wall. So Amrle Rav Papa but we're not going to paskin that way. Amrle Rav Papa braid Rav Acha bar Ada. So Rav Papa said, 1 second, Abaye, right? That was Abaye. Yeah. 1 second, Abaye. Haki Amrina Mishmei the Rabba. This was said in the name of Rabba. Kol mili dichte lo dichire ayanshi. When it comes to something that doesn't have any meaning, people will forget it. So as a result, that's really what's happening here. When he says it never happened, it's because it was a totally meaningless interchange between the two of them. And so as a result, even if the person were to say, Lo hayu dvarim ma'olam, and you have witnesses that actually say he admitted it, that is not sufficient. You need to have witnesses that were specified by the parties to be witnesses to the admission. So Hahuda Achman lay Edim Lechavre Bechilte. So a person hid witnesses behind bed curtains, and Amrle Mana Libiyadcha, and he said, "You owe me $100." Amrle Hain, and he said, "Yeah, I do." Amar Ire B'Shachve Lehevi Alach Sadeh. Can the people who are awake and sleeping all be witnesses to you? Meaning, presumably there are people sleeping here. Can you allow us to them to be witnesses? And maybe obviously he knew that there were people that were awake, but try to trick the defendant into admitting it. Amar lo, and he says no. Amar Rav Kahana said in that case, and where they bring the witnesses afterwards to say that he did admit it, but then again he says the next day that I was only joking. Amar lo, the guy said no, and so as a result, that's not a valid admission. Hahuda Achman Edim Bekivra Lechavre, the same story, but now it happened in a cemetery. Amar le Mana Libiyadcha, Amar le Hain. The guy admits that he has $100 that the other guy that he owes to the other guy. So Chayim Umei. Chaye umise lehevi alach sadeh. Can we allow the living and the dead to be witnesses? Amar lo, and the guy says no. Amar Rabbi Shimon. Amar lo. Again, he told you no. Sorry, but though that's not enough of an admission. If he's now saying that he was joking. Amar Rabina v'itema Rav Papa shmamina lo meha. We learn from this. Hada Amar Rav Yehuda Amar Rav. What we saw, Rav Yehuda said in the name of Rav, and of course that's how we began this whole discussion. Sarah sheyomer atem edai. You need to say that you're my witnesses. Loshna ki amar loba. It doesn't make a difference whether it's the debtor who says it, the one who's the defendant. Loshna ki amar malva. Doesn't make a difference if it's the lender, v'shasik loba. As long as the borrower is quiet. Time to amar lova lo, because we saw in these two cases that the reason that the decision was that it's not a valid admission is because the person said no. Aval ishasik hachik nami. But if in fact he had been quiet, then it would have been good, and then it would have been a good admission. Sahuda havu karule kav rishu. So there was a person. Now again, more stories that highlight this, some additional cases. Oh, I'm sorry, I did not scroll. I should scroll.
No, you would be chayiv in that case.
So
if he's
yes,
quiet, if he's quiet, he's chayiv.
If he's quiet, you'd be chayiv. That's exactly right. Hahuda havu kav rishu. There was a guy who was called, who had a name that was essentially kav of debt, meaning that everybody knew that he owed a lot of money. And so what did he say? Amar, the guy said, Man mazik be ela ploni uploni. Whom do I owe money to other than X and Y? Meaning, don't call me that name. I don't deserve that name because I only owe two people money, X and Y. Well, asa tava'uhu ladina kamei de Rav Nachman. So X and Y then come in to court and say in front of Rav Nachman and say, he admitted that he owes us money. So Amar Rav Nachman, Adam asli shalola hasbiya es atzmo. A person doesn't want to make themselves satisfied. They don't want to make themselves full. They don't want to make themselves look rich, is the way we understand that phrase. And so as a result, even though he's doing that in order to protect his reputation, that is not a sufficient admission for us. He needs to, again, appoint witnesses, or witnesses need to be appointed in front of him with him being quiet or being in agreement. There was a person who was referred to as a a mouse sleeping on dinarim because he would not give any money away. Ki kashachiv amar, but when he died, he said planya uplanya maskum zuze, that these two people have claims against me. Basar deshachiv, after he dies, asu tavinu layarshin, the two people come and claim money. Asu lakameh de Rabbi Yishmael Rabbi Yossi, so they come in front of Rabbi Yishmael, the son of Rabbi Yossi, and Amar lahu, and Rabbi Yishmael says, Ki amrin adam asri shelo lahaspia esas. But when do we say that a person doesn't want to make himself look rich? Hani mili mechayim, that's when he's alive. Avala achar misalo, but not after death. So paru palgo, so the heirs paid half of the amount. Well, tavinu ladina leidach palgo, so they sued for the other half. Azul kamei de Rabbi Chia, and that came in front of Rabbi Chia. Amar lahu, Rabbi Chia said, "Kashem sha'adam asui shelo lahaspia es atzmo, kach adam asui shelo lahaspia es banav." Just as a person doesn't want to make himself look rich, he also doesn't want to make his children look rich. And so therefore, when he said this, when this person who's like a mouse who sleeps on dinarim, who is very stingy, says that he owes money on his deathbed, it does not count as a confession. So Amruleh, Nizal v'nihader, do we have to go back and give the money, the half of the money that we got already? Amrlo, kvar horelach zaken. No, an elder already ruled for you, and so as a result, you do not need to give it back.
Why did they give the money?
What?
Why did they even give the money if they didn't have to?
No. The ending result, remember, they came before Rabbi Yishmael, the son of Rabbi Yossi, and Rabbi Yishmael, the son of Rabbi Yossi, said only a person in their lifetime doesn't want to make themselves look rich. But when he says it on his deathbed, we are going to believe him. And so as a result, the first court case that they went to, they were found guilty and they were found liable. The heirs were. And so as a result,
the heirs aren't liable. It's the man himself, right?
No, but the person who died, so his heirs are liable.
Well, okay, but they weren't initially liable.
Yeah, of course not. But the point is the person who passed away is liable, and therefore his heirs need to pay the amount, and they only paid half. And then they went to a different judge. They went to Rabbi Chia, who disagreed. And Rabbi Chia, which is actually, I believe, the way we paskin, we actually paskin that that even an admission on the deathbed can be made, as we saw at the end of Baba Basra, can be made in order to try and prevent your heirs from looking rich. And so as a result, that is not sufficient to make a claim. But rather, we'll say that, oh, no, he just wanted to not look too rich to the rest of the world.
So therefore, they shouldn't have to pay, should not.
Well, no, the question that was asked is, do we need to pay back the half of the money
exactly.
that we
they
got
shouldn't
from
have paid
the heirs?
In the first place.
And right, they shouldn't have paid in the first place. And the answer is because they got a full-fledged decision by Rabbi Yishmael, the son of Rabbi Yossi, you do not need to return the money. So essentially, what we end up with, this highlights that sometimes you can have wrong decisions that are still somewhat right. Meaning there was a justification that Rabbi Yishmael, the son of Rabbi Yossi, came to, and even though it got overturned, and therefore the second half of the money doesn't get owed, the fact that you've already dealt with the first half of the money, we're going to say that that's over and done with, and we're not going to make the person go back. So, all right, we're going to pick up now. We're going to add wrinkles to the cases of admission. What happens if there's a kinyan? What happens if there are three witnesses? Because the three witnesses could serve as a beit din. So in those two situations, what's the story? So for that, you'll have to stay tuned.
But why would we, if the case, it seems like a case of an appeal. In today's courts, you have in the lower court, then a higher court, Supreme Court. So if
yes, this is not an appeal. This was not an appeal. This was an effort at collection. This is, you had a judgment and the judgment was partially collected, and now you're trying to finish the collection.
I understand
that. And the second judge says that the first judgment is not correct, but because you already collected the first half, we're going to keep that.
But why isn't this like an appeal? They say, no, we shouldn't have had to pay in the first place.
Because it's not an appeal, because we don't have, an appellate system in Judaism. The court is effectively the last resort. And so as a result, the first court ruled for the plaintiffs. And so as a result, and they were able to collect half. The second court, even though it's the same facts, when it came to collecting the second half, ruled for the defendants. And so in the end, what you have is the successful collection of half of the debt and the unsuccessful collection of half the debt.
But essentially, the second court is saying this shouldn't have happened. You shouldn't have had to pay
You're
anything.
absolutely right.
Because you're
You're
not
absolutely right.
responsible. The father and what he made, he said he was just
100%.
saying it. He said what his words were meaningless. So you shouldn't have had to pay. Why? I mean, it's hard to understand if that's the case and the first court ruled wrong. Let's say the second court, then shouldn't that group have to pay the money back? Give the money
Part
back?
of the lessons, that's exactly right. Part of the lessons of this Gemara are that when there is a basis for the first court's ruling, and it's not completely wrong on its face, then we will not undo the first court's ruling. And so since they already collected half based on the first court's ruling, we're going to allow them to keep that first half. You're absolutely right that this is not an automatic thing. That doesn't necessarily have to follow. You're absolutely right, but that is exactly what the Gemara is teaching us. That in this case, when you have a legitimate judge reach a legitimate decision, even though a later court effectively finds that decision completely wrong, as long as it's not really wrong, meaning as long as it doesn't contradict other clear Mishnah, a clear halacha, we're going to say that original decision has some validity, and therefore you don't have to return money that was collected based upon it.
We have a whole series of discussions in Baba Batra and so forth where there were sharecroppers, there were this, that, and the other, and we say that the person has to return the money, right? Aren't there situations like that? If one takes money from someone and it's wrong, taken incorrectly, so the other one has to return the money.
Yes, but those are all situations either not where the court found necessarily that the person did the court. I don't believe those situations involve court approval, and if they did, they were situations where either the court did not have all the facts or the court reached a decision that is clearly wrong. As opposed to here, where it's not clearly wrong, it's just Rebbe Chia disagreed with the decision of the earlier court. Okay? All right, we'll pick up from there, God willing, tomorrow. Looking forward to talking about what happens if there's a kinyan and what happens if there are 3 witnesses. See you then.